In doing so, Trump certainly upends the modern scholarly consensus about the meaning of the Citizenship Clause. But he also gets it right. He gets it right as a matter of constitutional originalism, as I will explain, and as my debate partner will explain, he also gets it right as a matter of sound public policy. President Trump's order is perfectly consistent with the original public meaning of the Citizenship Clause. Clearly, the 14th Amendment indicates that citizenship is the automatic birthright of at least some people by virtue of their birth on U.S. soil. But birth in the United States is not the sole qualification in the text. A person must also be born subject to the jurisdiction thereof. While our long-standing national policy has been to largely ignore that second condition, it was not superfluous to the people who drafted and ratified the 14th Amendment. It had an actual meaning. It limited birthright citizenship to those who, like the descendants of slaves with which Congress was primarily concerned, were subject to the complete political jurisdiction of the United States and were not meaningfully subject to any foreign power. The congressional debates and surrounding legal history demonstrate that this was an allegiance-based birthright citizenship concerned with factors like permanent domicile, lawful presence, and our mutual acceptance of one's desire to join and participate in the American body politic. Now, our friends on the other side of this argument would have you believe that this allegiance-based interpretation of citizenship is not just historically wrong, but historically unprecedented. They will make an argument which will undoubtedly be familiar to most of you, that the 14th Amendment's grant of birthright citizenship is virtually unqualified and universally applicable. They'll tell you that it just adopts an old English common law rule of use solely, this ancient feudalistic principle under which your subjectship is irrevocably dictated by the accident of your birth upon a specific lord's land, and then you owe that lord a duty of perpetual allegiance, a tie, a bond which you can never sever. And they would have you believe that because the Citizenship Clause is just used solely by another name, that the phrase subject to the jurisdiction thereof is almost redundant. It was meant only to exclude the children born of invading armies or the handful of accredited ambassadors we had at the time. And they'll also probably admit that it excludes tribally affiliated Native Americans, which really probably would not have been true under the English version of just solely. And then they will tell you that it doesn't matter what we or Donald Trump think about the original public meaning of the Citizenship Clause, because the Supreme Court definitively settled this question in 1898 when it said that all persons born in the United States are citizens because used solely. But if our friends are correct and Trump is wrong, history has some questions. And those questions all invariably begin with the same word: why? If birthright citizenship is universally applicable, why did Congress's first effort to define its parameters, the 1866 Civil Rights Act, limit it to those who were born in the United States and not subject to any foreign power, and also exclude Indians not taxed? Why did Senator Lyman Trumbull, the very accomplished attorney responsible for that language, explain for his fellow members of Congress that they chose this language precisely to exclude from birthright citizenship those who owed only a qualified or temporary allegiance, something that under the common law rule would have been sufficient for citizenship? And why does he specifically note that under the American version of this, it excludes the children of temporarily resident aliens, quote, whom we have no right to make citizens? Why, when these same members of Congress go on to constitutionalize the protections of the Civil Rights Act and the 14th Amendment, do they all seem to agree that the phrase subject to the jurisdiction thereof meant the same thing as not subject to any foreign power? And why are the debates over the 14th Amendment citizenship language centered on how best to exclude large categories of people who aren't subject to the fullest extent of our national jurisdiction, including Native Americans who are literally within the geographic confines of the United States? And why, around the same time that we are supposedly adopting an English common why is his interpretation so consistent with the earliest interpretation by the executive branch? Why, for example, in 1872, does Attorney General George Williams, himself a former senator who sat on the Joint Committee for Reconstruction and was heavily involved in the debates over the 14th Amendment's language, why does he explain that when the Citizenship Clause says jurisdiction, it doesn't mean basically everyone, but only those subject to an absolute or complete jurisdiction? And why does he go on to explain that, quote, aliens dwelling in the country are subject to the jurisdiction of the United States only to a limited extent? Why? Because military and political rights do not pertain to them. Why, in 1875, does Yale's tenured professor of common law, someone very familiar with principles of jus soli, clarify in his legal treatise that under the 14th Amendment, quote, a native-born citizen is one who is born within the jurisdiction and allegiance of the United States, which he clarifies includes only persons born of citizens or born in the United States of permanently domiciled aliens. If President Trump is wrong, why in the 1880s do legal stalwarts like Thomas Cooley, one of the nation's most widely cited and respected expositors of constitutional law, why does he write things in his common law treatise like, quote, to be a citizen by birth, a person must not only be born within the United States, but he must also be subject to the jurisdiction thereof, and by this is meant that full and complete jurisdiction to which citizens generally are subject, and not any qualified impartial jurisdiction, such as may consist with allegiance to some other government. Why in 1881 does Alexander Porter Morse write that, quote, jurisdiction must be understood to mean absolute and complete jurisdiction, and that because the allegiance of children follows the allegiance of parents, at least under well and widely understood and recognized concepts of international law, why then does he go on to explain that the U.S.-born children of aliens are not to be regarded as citizens because they are all subjects of foreign powers? And why does Francis Wharton similarly limit birthright citizenship according to this principle? If President Trump is wrong, why do the earliest state, federal, and international arbitration decisions to analyze and apply the Citizenship Clause focus not on the mere fact of birth on U.S. soil, but heavily emphasize factors like lawful permanent domicile, participation in the American body politic, and whether or not there's continued allegiance to a foreign power, factors that are completely irrelevant under the English common law rule. Now, our friends on the other side are correct, and Trump's actions are completely unprecedented and his reasoning completely ahistorical. Why, in the 1880s and 1890s, did multiple executive branch officials, spanning multiple administrations, headed by different parties, make precisely the same determinations about granting or denying citizenship documents based on almost identical factors to those laid out in President Trump's order? Why, for example, in 1885, does the State Department very diplomatically tell Richard Brycer to pound sand when he asks for a U.S. passport? Why does it determine that Brycer, who everyone agrees was born in Ohio, why does it nonetheless say that he wasn't born subject to the jurisdiction of the United States for purposes of the 14th Amendment? Why does it matter to them, if it's just jus soli, that his parents were German subjects, here only temporarily, who brought him back as a toddler to Germany and raised him as a German? Why in 1890 does the State Department similarly deny citizenship claims for the U.S.-born child of a would-be immigrant who was ultimately deported as an inadmissible alien? Why do they reason that the woman's inability to attain lawful permanent residence is relevant at all under jus soli to whether her child was born subject to our complete jurisdiction? And if the Supreme Court really did decide in an 1898 case called Blanc-Marc that basically all persons born on U.S. soil are citizens irrespective of the parent's immigration status, why is that case actually about the U.S.-born child of lawfully present and permanently domiciled immigrants who himself was born and raised and permanently domiciled in the United States. Why, if you read its holding, is it actually limited to that specific scenario? And why does the court, in that opinion, repeatedly stress the importance of factors like lawful presence and permanent domicile of the parents, factors that, again, are utterly irrelevant under actual common law use solely? If Wong-Kim Ark settles this question, why, even into the 1920s, are legal scholars like Henry Campbell Black, yes, that Black from that Black's Law Dictionary, why is he still writing in constitutional law treatises that birthright citizenship, even after Wong-Kim Ark, applies, yes, to the U.S.-born children of permanently resident aliens regardless of race, but not to the U.S.-born children of temporarily resident aliens who claim to owe us no allegiance, or to those who are among the accepted classes, by which he presumably means excludable and admissible aliens. All of these historical realities exist and are shockingly consistent with President Trump's arguments because Trump is correct about the original public meaning of the Citizenship Clause. Meanwhile, our friend's interpretation of it is a thoroughly modern reinvention. Consider the why of the 14th Amendment. Congress did not draft the constitutional definition of birthright citizenship in some theoretical vacuum. Rather, it was unquestionably resolving one very specific problem: how to undo the moral atrocity of the Supreme Court's decision in Dred Scott v. Sandford. Dred Scott held that the U.S.-born descendants of African slaves were not and could never become citizens based solely on their race, and despite them not plausibly owing allegiance to any other sovereign. It effectively relegated Black people in the United States to the status of permanent aliens in the country to which their ancestors had been forcibly removed, and in which they for generations had been born and lived and died. The Citizenship Clause and the Civil Rights Act before it were absolutely efforts to remove these race-based barriers to citizenship. But the debates make it clear that Congress did not accomplish this by ingrafting principles of feudalism into our nation's charter and by making citizens of virtually all persons born here, irrespective of the nature of their relationship to this nation. Instead, informed by Republican small r principles, they resolved a uniquely American problem with a uniquely American understanding of citizenship. This Americanized conception of citizenship was as little about the mere accident of birth on our soil as it was about the mere accident of the race into